going on, or do you need this reset for another day?
I'm going on probation, right?
Well, I don't know.
Oh.
Do you understand what we're doing today?
Mhm.
That you're
This is the third time she's probably learned her lesson from stealing. Why do you keep stealing? And I guess the reason why they didn't do it is because she had a pending out of county case.
Yeah, I'm taking her to custody, right?
Yes.
Oh.
And I don't know, counsel, if she has,
Oh, I don't. 10
do
years.
you not understand or do you not want to understand?
Don't understand. 10 years for what?
You're on probation for a third-degree felony.
My client into signing a divorce decree to get this settled so that she could live in peace the last time. She is not, in fact, terminally ill, nor was she ever terminally ill. And if she is going to continue living, which is great, good for her, but if she's going to continue, obviously the marital property needs to be divided appropriately, including the business. That's
Your Honor, it's been some time since the incident. Since something happened recently. She is in a better place now in her life. She's employed. She's 9 months pregnant. She's set to give birth here in about 12 days or so. She's in a good place, and she thinks that has learned her lesson and will definitely comply with probation.
All right, so this is the third time she's probably learned her lesson from stealing. Why do you keep stealing?
Before I wasn't in a better position than what I am now, and that was something that I picked up in a bad habit.
What, a bad habit of stealing?
Yes.
How do you develop a habit for stealing?
It was just something that I chose to do. It was a choice. And
But I mean,
now,
I'm just trying to figure out, how do you develop the habit for stealing?
it just happened, and
Well, I mean,
Something
did you
that
all
was-
plan? Did you all say, hey, let's go to Don and Ben's and take tequila?
no, it wasn't anything like that. Like I said, I was in a bad predicament, and I was using that to like pay rent or do any, just making any
No, I
type
don't
of-
know. Because, and let me just explain to you why I don't realize that.
Understand.
Because people will spend money on their wants, but not on their needs.
Right.
And what I'm reading in here, everybody in the vehicle was dressed to the nines. So obviously there was money for clothes, there was money for hair, there was money for nails, there was money for gold, there was money for gold grills, but then people are saying they're stealing for other things that I don't understand.
Right.
And then going to Don and Ben's, the officer said that the car smelled of marijuana, and you all just went to Don and Ben's grabbing tequila. So I don't understand when people say, oh, I needed rent. Who's out here buying stolen tequila?
I don't smoke, so I don't know.
No, I said, who's out here buying stolen tequila? Did you take orders where you just say, hey, anybody want tequila? Because it's saying that you took
6 bottles.
yes, of tequila, 2 coconut bottles, reposado,
Yes.
and
Irregular.
so see, she remembers. So why? So that you all could drink and have a good time. How old are you?
I'm 28. I was 7 then at the time, and that was just how I was making my money. There's no excuse for it. I'm not making no excuse for it. And like I said, that's something that I'm not doing anymore.
And the people you were with, this Latasia Bateman, who is that?
Just a friend of mine,
And
or
who-
was a friend of mine.
All right, and who is this? I guess their mom named them T.I. Era Barber.
Yes,
Who is that?
just another friend.
What does T.I. stand for? Is that their name,
I
T.I.?
think it's Tierra.
Oh, the officer then put an apostrophe. Okay.
Right.
All right, court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. If you were drug tested today, what would the results be?
I'm gonna be clean.
Okay. There's to be regular UAs, regular reporting by Zoom or in person. Are you employed?
Yes, ma'am.
What do you do?
I work for home health.
Doing what?
Pretty much like assisting and aiding. I'm with.
What does that mean,
DSP.
assisting and aiding?
I pretty much help feed, change clothes.
The credential or you like a CNA?
I'm not a CNA, I'm just a caregiver.
No, do you go into people's homes and do this? I don't allow people on probation in this.
This is
court.
the actual, it's like a nursing home. It's not just like a home. It's a, like, it's a nursing home, like an actual,
So she doesn't go on.
so it doesn't go into people's houses. It's a actual facility.
All right, I'm not going to allow you to continue to work there unless I receive a letter from your employer stating that they know what you're charged with and you can still work there. And then the people that you're taking care of, they either need to sign something or their relatives need to know that you're working there.
100%.
All right, then their relatives need to know that you're working there. That's, Ms. Abrams, that's what I'm ordering. So proof of employment within 30 days. No employment with minors.
She is on maternity leave right now, so I don't know if you might be able to extend 30 days out a little bit longer than that.
Oh, just speak to probation about that. I consider myself to be reasonable.
Just thought I'd put that on the record.
I appreciate it.
Because I mean, it'd be, 30 days from 2 weeks and then.
Oh, trust me, probation will say she's on maternity leave. And I'll say, okay. There's to be no employment as a home health care provider in someone's residence. And also, she's not to be a home health care provider at a facility without a letter from the employer stating that they are aware of her criminal history and she's allowed to work there. And the family members or whoever she's caring for is aware of a criminal history and they have no objection to their working there. Field visits 1 time per month for 3 months. 200 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, 100 of those hours will be waived. And then I'm going to order the theft course. Once that's complete, the remaining hours will be waived. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Oh, and I'm sorry, just one other thing. There's to be no contact, Lastasia, Lastasia, Bateman, Batman, and Tierra, Tierra, Barber, Barber. All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. If you need anything, let probation know. If you feel as though they're not addressing it, you can always come back to the court.
Thank you.
All right, you're welcome.
Yeah.
What, just remain in court probation 24 CR 008663, State versus Imani Robinson. Could I have parties announced for the record?
David Andre Woodard for Imani.
And are you Miss Robinson?
Yes, ma'am.
All right, defense, you're here requesting a bond, is that correct?
Correct, Judge.
All right, and defense, what bond amount are you requesting, or is there an agreement? On this case, she's currently on probation. Is there any conditions that need to be added as far as any no contact orders, any mental health or drug issues that need to be addressed with the bond? Thank you. Has your client, since I've last seen her, has there been any type of mental health issues, any mental health diagnosis?
Not to my knowledge, Judge. No, Judge, she doesn't wish to speak.
All right. There's going to be, the court will follow your agreed order. There's a $7,000 bond, full GPS waive fees. There's to be no contact with the complainant. And the court's order is to be entered on November 21st, state. And the reason why it's November 21st is because the complainant needs to be notified that she'll be released. If you're able to contact the complainant today, then it can be entered into the system today. Right, the contestant will be for December 16th. Normally, if you'll give a reset form for December 16th. All right. Now, you wanted to address an issue?
I do, Judge.
Yes.
GPS was ordered by the court.
Mhm.
And I filed a motion to set bond, the court set a bond and also put GPS as a condition.
Mhm.
Ms. Robinson made bond, but she was never released because of the GPS issue. She
Mhm.
made bond back on November 21st, 2025.
Mhm.
She since has still been in custody. So we're asking for if we can possibly remove the GPS as a condition because it's still keeping her. in
So
custody.
why isn't she able to have GPS?
I'm not certain, Judge. The rest-
Judge, if I may. There was an outstanding case in another county
Mhm.
that, has been taken care of. I received an email yesterday morning.
Mhm.
That case has been taken care of. Once, we're ready to go with this case, GPS can be installed before she's released.
All right, so they say now they can have GPS installed. And I guess the reason why they didn't do it is because she had a pending out-of-county case.
Would there be a timeline on when she would get the GPS? 'Cause
Oh, it should be quickly done, oh, no later than Tuesday.
Yes, before she's released, I mean, the email response that I received from yesterday, it had to do with the bench warrant from the other county. They got everything squared away, so, I'll respond to that email right now.
And then council, as you know, when somebody has a pending case out of county, they're not gonna put them on GPS because that other county is picking them up. And they're not gonna have you with GPS when you're at the jail. So-
That case has been disposed of now to my understanding.
Yes, so she'll be able to get the GPS. And council, if the GPS is not on by Tuesday, you can just come in and let the court know.
Will do, Judge.
All right, thank you. In 2024 CR 008-663 State versus Imani Robinson, can I have parties announced?
Galloway for the state.
David Andre Woodard from Ms. Robinson.
And are you Miss Robinson?
Yes, ma'am.
If you review the documents entitled motion to revoke community supervision and first
We're on the
amendment
record.
motion to revoke thank you. To revoke community supervision with your attorney, did you understand it? Okay. Are you the same Imani Renee Robinson who was placed on community supervision in 2024 CR 008-663 for the offense of theft of property less than $2,500 with 2 or more convictions on December 5th, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Violation of condition number 4 in Bear County, Texas, the defendant Imani Renee Robinson did then and there fail to report to the supervision officer as directed for the months of May, June, July, August, September, and October 2025 in violation of condition number 4.
How you plead to that, true or not true?
True.
Judge, we even abandoned the remainder.
Any objections?
No objections, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility and up to a $2,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Judge, this is the defendant's first MTR. We are asking that the court deny the state's motion and alter and amend her conditions to include the hostility management course and a no contact order with Taylan Mackey, and that is TALIAN MACKEY.
So why hasn't she reported?
Judge, when I spoke with Imani regarding not reporting, I think what happened is the new offense had occurred. She knew that she would likely have a warrant, and I think she got fearful of reporting to probation. So instead of doing what she should have done first, we're here now in this motion to revoke with months of not reporting. As the state mentioned, this is her first MTR. She has been on GPS monitor since the court set a bond for her, and she's had no issues on the monitor. So we're respectfully asking the court to follow the state's recommendation and try to get Ms. Robinson back on track so that she can successfully complete her probation.
How old are you?
29.
All right, I'm gonna give you a choice. These are your only choices. There are no other choices. One, I can revoke you, and if there's no objection, I'll sentence you under 1244 to 300 days in the Bear County Jail. Or two, I continue you, and as a condition of your probation, you're going to do some jail time, and it'll be 30 days jail. Which do you prefer? You need to discuss that with her?
I would like to, Judge, before she makes a decision.
All right, thank you.
Let's go ahead and see.
And say,
Ready on Ms. Robinson.
all right, she'll come forward. We're back on the record in 2024 CR 008663. So counsel, what has your client decided?
Which decision are you going to do?
On the record, let's keep it down.
30 days and continue on 300 days.
I want to be my 300.
All right. Oh, do you have the,
I think you have turned it into the clerk.
all right, can I have a trial court certification, please? All right, court is finding violation of condition number 4 true. Court will sentence you under, well, the court will revoke. Sentence you to 300 days in the Bear County Jail under 1244. Give you credit for any time served. There's to be no contact with Don and Ben's, BEN''S. There's to be no contact with Talon, I believe it's Talon McKee.
I believe that was the name the state put on the record, Judge.
All right, is there anything else with regards to sentencing?
No, Your Honor.
All right, let's review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it and did you sign it?
Yeah.
Yes or no? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thanks, Judge.
Thank you.
Yeah, you're taking her into custody, right?
Yes.
Oh.
And I don't know, counsel, if she has anyone here that she has things she would like to give to them.
Yes, I thought I said, we're gonna do that. Give her an opportunity.
I feel it's a plea bargain case, and you have the right to appeal, okay? This is not a plea bargain case. Okay,
It's just probation.
I'm sorry,
It's just probation we talking about, huh?
well, you're on probation, but she can take it away if she deems that appropriate. But this is a certification that you have. This is not a plea bargain case, and you have a right to appeal.
But then,
You want me to? Judge, I'm gonna have to set it for a contested hearing because client is asking pertinent questions about it, and may we recall it next week sometime or tomorrow?
No.
I need
It's
to
gonna
set,
be set at a contested hearing. Mr. Leal, we've been here since 9.
I understand, Judge.
All right, so here's the thing, Mr. Ellison, this is a contract with the court. It's not a contract with the state or with your attorney. So you can negotiate with the state, but it's not binding upon the court. So if you want a contested hearing, we will recall it back for a contested hearing, but it will be a contested hearing. The state will be bringing witnesses to seek to prove up the violations that are in the motion to revoke. Do you understand?
no, I was just trying to see if I can get it continued. I was working. I was trying to.
Now, here's the thing. You're not at the phase where I'm to listen to what your reasons for why maybe the allegations in the motion are true or not true. Where we're at right now is I am explaining to you that you can't reach a binding agreement with the state and have it binding upon the court. So what that means is If you and the state come to an agreement, I don't have to follow it. Your range of punishment in this case, if I were to grant the motion to revoke, is up to 10 years in the prison. Do you understand?
No, I don't. 10 years.
Do you not understand or do you not want to understand?
I don't understand. 10 years for what?
You're on probation for a third-degree felony. You understand you're on probation?
I missed the stipulation, so I didn't call.
Yeah, that's what they're alleging, that you were unsuccessful and that you violated or did not complete certain things that they asked of you.
My first
So we can either
violation
go forward now or either I can set it for a contested. Which would you prefer?
was a contested.
Or they have to bring live witnesses to prove the allegations. Like these allegations. That we went on.
Bring live witnesses to prove that I didn't meet stipulation.
5 CR 003409 State versus Irvin Earl Ellison. Could I have parties announced for the record?
Galloway for the state.
Rafael Leal for Mr. Ellison.
And are you Mr. Ellison?
No,
All right, Mr. Ellison, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
yes, ma'am.
Did you understand it?
Yes, ma'am.
All right. Are you the same Irvin Earl Ellison who was placed on deferred adjudication in 2025 CR 003409 for the offense of obstruction or retaliation on June 17, 2025 for a period of 2 years? Is that you?
That's correct.
All right, state.
Violation of condition number 4 in Bexar County, Texas. The defendant Irvin Earl Ellison did then and there fail to report to the supervision officer as directed for the months of July and August of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
You waive and abandon the remainders, Your Honor.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. State, what are you recommending?
In the court to grant the state's motion and turn adjudication of guilt against the defendant, revoke him and sentence him to 5 years in prison, based upon the plea of true, and we would take into consideration cause number 2025 PF 5850.
All right, in defense, what are you requesting?
Judge, I'm requesting that he be continue on probation, either defer or with a conviction. My client was homeless. He didn't have an address, was trying to get his life together. To his credit, he called the probation office, left a message telling the officer of his condition and what was going on. He was mainly focused on getting his life together, and perhaps did not appreciate that he needed to report beginning with the intake, and he failed to do that. But when you don't have a home, a roof over your head, no money, going hungry for all the, once he was released, that's what clouded his judgment, in my opinion, Judge. And we're asking, when he was arrested, when he was just got a telephone and was in the process of calling the office to report. And we're asking that the judge, that the court continue his probation, and because I don't think the solution it is just to send him to prison. I think he should have that opportunity and perhaps take advantage of it.
So has he done anything?
He didn't have an opportunity to do that, Judge. He wasn't, he wasn't directed with an intake as to what to do or what to, or
What do you
what.
mean he wasn't? So he wasn't told that he had to report?
I believe he was released, George, from either jail or from here when he took the plea, and to his credit, he called once, and
So you're saying he didn't know that he had to report?
that's not what I'm saying. I believe he was told, except that he didn't register,
So he's never reported?
never reported, except by telephone on
Uh,
one occasion.
Probation? Has he done anything? Has he ever reported? All right, so you're telling me that Miss Abrams never told him?
No, that's not. He was told when he was released as to what he needed to do, and he was probably even given a number to call, and he did call that number, except that he didn't follow up with that.
So you want to call your client as a witness?
Yes, Your Honor.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
So I do
All right, you can lower your hand, state your name for the record.
Reverend Earl Ellison Jr.
All right, you may proceed.
Mr. Anderson, when you were released, either June 17 of this year or June 18, were you given a number of the probation office and perhaps even a name of your probation officer to report to?
Yes, as soon as I was released, I used the phone in the lobby to make the phone call, and I left a voice message.
And what did your voice message contain?
I told him my name, and told him that I was checking in, and that was that.
Now, at that point, when you made that telephone call, did you have your own cell phone at the time?
No, I did not have my own cell phone. I actually just got it the day of the arrest, of the new arrest.
So you use somebody's telephone, either an office telephone or some other telephone?
I used the lobby payphone. Right before you walk out of the doors, when you get your cards, and you get your property.
Was that from the jail or from?
That is from the jail.
Okay. And what was your understanding? I mean, when you were given that telephone number, and were they your obligations? And were you informed of what your obligations were?
Well, I checked in. I knew that I would possibly have to try to make another phone call. However, I had no way of communicating or reaching out with anyone. So I would do small work, pick up trash and lots or whatever. I eventually earned myself a cell phone, and that's when I got arrested, and I was looking forward to actually making a phone call and continuing on with any said stipulation or whatever it may be. It wasn't
So you were trying to work on a daily job or some other type of activity?
yes, I was too.
Okay. And did you have a place of residence at the time?
At the time, no, I didn't.
Where were you living?
I was on the streets. If not, I would try to check in the Salvation Army.
Okay. And did you know when you were released that you were supposed to report in person to the probation office?
After release, no.
Okay. What would you like? I mean, what's going to be different if the judge were to continue you on probation? What's going to be different? How can you assure the court that you're going to be compliant with your obligations of community supervision or probation?
For now, if I get released, I'll be able to make phone calls and actually keep contact. That way I can have thorough communication. I can follow through upon any stipulation that is given for probation.
And that's what you wish the court to do to reinstate you?
That is what I wish for the court to do, to reinstate.
And, but the question is still gonna be, why didn't you do that the first time?
Trying. Out there trying to do better for myself.
But you understand that, to do better for yourself includes following up on your obligations and your community supervision.
Yes, I do, and I do sincerely apologize for my mistake. It gave me another opportunity. I capitalized on it.
That's the way it is.
Okay,
Questions?
Mr. Ellison, so you were released from jail in around, like June of 2025, is that correct?
I'm not too sure. I'm thinking so.
It was earlier this year, right? Okay, and so when you took a plea on this case, correct?
Correct.
Okay, and you were placed on deferred adjudication, correct?
That's correct.
Okay, and the underlying facts of the case that you're here for today is because you told a police officer that you would fucking kill him. Do you recall that at the Chick-fil-A?
Probably said something different, but I do recall communicating with the police officer to
Okay, and so it's your testimony that when you were released from jail back in June of 2025, before you took off from jail, you made a phone call to probation. Is that correct?
That's correct.
Okay, but when you took a plea in this case, Ms. Abrams went over the conditions of probation with you, correct?
That's correct.
Okay, and she let you know that you could report in person or by telephone. Is that correct, to adult probation, right?
That's correct.
Okay, and so she also told you that you could reach out to probation in email form, right?
I'm not too sure. I was told that it was
In person or phone.
right.
Okay, and so the way that you ended up in court here today is because you went to a Walmart in September of 2025, about a month ago, correct?
Correct.
Okay, and you were placed under arrest at that Walmart, correct?
Wendy's. That's correct.
Okay, that's how you're here today, right?
That's,
Okay, and so when you were at that Walmart, it was alleged that you took a pair of headphones that cost $157 and didn't pay for those headphones. Isn't that right?
That's right.
Okay, and so my question to you is, how did you get to Walmart that day, but you cannot get to adult probation to comply with your conditions?
Walked
You walked to Walmart.
to Walmart.
Okay, and you acknowledge that you could have walked to adult probation to report, correct?
I don't even know where it's at.
So you weren't informed that it's across the street from the jail at 200 North Comal?
I don't remember that.
All right.
I
And
just tried to make the
so,
call.
I'm sorry?
I was just trying to make the call that way I can continue communication with.
All right. And so you didn't, you were arrested, and then that's how you ended up here today. And you stated that in between the time that you haven't reported, that you've been trying to do better. Is that your testimony to the court?
That's correct.
Okay, and by doing that, are you trying to do better by committing thefts of headphones?
No,
Would that be considered you trying to do better?
I'm not.
You passed the witness.
No further questions.
All right. Is there anything else?
No,
All right. So, Mr. Ellison, I understand that when people are homeless, maybe they're not able to get from point A to point B, but you haven't done anything on probation other than pick up new charges. That's not good. And in this court, I always tell people communicate. And if there's an issue, we can try to solve that, but no one can help you solve your issues if you don't communicate with anyone. And one of I wouldn't say the worst thing, but being on probation and picking up new charges is not something good, because that shows that you can find the wherewithal to steal, but you can't find the wherewithal to get in contact with probation, which is across the street from the jail. All right, this is what the court is going to do. The court is finding violation of condition number 4 true. The court will take in consideration 2025 PF 35850, give you credit for any time served. and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal, I'm sorry, the court is finding you guilty and revoking. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Like what just happened?
You have been revoked and you're going to go to the prison. And when I say go to the prison, they may end up paroling you from the jail. I don't know, because I don't know what credit you have in for time, or they may take you to the prison and process you there and parole you. But I've sentenced you to 4 years. Anytime that you've been in custody, you'll receive credit for that on this case. Legally, that is the law.
How much time?
I don't know how much time you have in. To the clerk, do you know how much time credit he has? Charged with possession of a controlled substance, penalty group 2, 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Do you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He certainly has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes and yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both of those.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
All right. Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did. Yes, ma'am.
According to the plea, there's a $1,500 fine to be probated. State recommends deferred adjudication, and there's to be restitution for drug testing to the Bexar County Crime Lab. Did you understand that to be the plea?
Yes, Your Honor.
Yes, Your Honor.
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you sign it in both places?
Yes.
And did you understand it?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motion?
There have not.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service restitution, the DOEP course, and random UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Did you say we signed it as guilty?
Yeah, guilty.
All right, state, any evidence?
State Office of Evidence states one in its attachment.
We reviewed them and have no objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did. Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes.
All right, you're slow on the reaction time. What's going on?
Oh, so I worked 18 hours yesterday. I didn't get home till 3 a.m.
Okay.
I'm a little exhausted.
All right, so are you understanding what's going on, or do you need this reset for another day?
I'm going on probation, right?
Well, I don't know.
Oh,
Do you understand what we're doing today?
Mhm.
That you've asked for 3 years deferred adjudication? Say yes or no.
Yes.
Okay. Are you comfortable proceeding today, or are you falling asleep that you can't do it today? Do you
Let's
want
do
to?
it today.
Okay.
Right. So with regards to the waiver and stipulations, you reviewed that with your attorney?
Yes, ma'am.
You understand it?
I do.
You signed it in all the appropriate places?
Yes, ma'am.
You still understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Mhm.
Yes or
Yes,
no?
ma'am. Yes, ma'am.
How old are you?
31.
All right, so it's yes or no, right?
Yes, ma'am.
Okay. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, please.
Anything you wish to say on behalf of your client?
Judge, the one thing I'd like to point out for the court is my client, as he's mentioned, does work very hard. He works for a garage door company and they do travel. He was in Houston recently and some other places. He sometimes pulls 24-hour shifts when they're doing big jobs at Walmart and things like that. So I just want to make sure that the court is aware of that, just in case it presents some problem. I've explained to him that he'll have to report typically once a month, and that possibly that can be on Zoom. And so, but like I said, I just wanted to make the court aware of his work schedule.
All right, who is Judy Monroe Mendiola to you?
Judy. I
The
don't
person
know.
who was in the vehicle.
Oh, Judy. She was just a friend of a friend.
All right, and who is Manuel Maris, the fourth to you?
He's just a friend.
All right, none anymore. So this is what the court is going to do. There's 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. The defendant is allowed to travel throughout Texas for employment. There should be no contact with Judy Monroe Mendiola and Manuel Maris, Mares, the fourth. Proof of employment within 30 days. No employment as a home health care provider or with minors. TAP evaluation out of custody. Follow recommendations. $1,500 fine. That's to be probated. Field visits 1 time per month for 8 months. Restitution to the Bexar County Crime Lab for drug testing. Do you have any children?
No, ma'am.
100 hours of community service restitution. He can either do those hours or he can pay it off at $7.25 per hour to the San Antonio Food Bank.
Okay. Thank you, Judge.
All right. And if there's somewhere else he would like to pay that, it just needs to be a place that's approved by probation.
Okay.
I only suggest that because, as you know, they always have a shortage.
Sure. Definitely. I told my client before we got up here, I've encouraged him to take the class as quickly as possible and do the community service hours as quickly as possible, because I think his intent is to prove to you that he can get off this probation sooner, hopefully. So.
All right. Do you live by yourself?
I live with family.
Any minors in the household?
My little cousin. He's 10.
All right. So no unsupervised contact with minors.
Okay. Yes, ma'am.
All right. Is there anything else?
No, Judge, thank you.
Probation, is there anything else?
No, you're-
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did. Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, in probation, he can either do the regular random UAs or either he can do the patch. Patch costs more, but it's more conducive to people who have time issues, and your attorney can explain that.
Instead of having to drive down to probation, they can give you a patch that determines whether or not you're using drugs. But you don't have to go down to probation once a month, sort of. So that might be easy for you.
Yeah, I'm just out of town a lot. I'm
So the
I work
patch,
a lot.
so the patch might work better for you then, instead of having to make your way down to probation.
I mean, it's completely up to you. Here's the thing about the patch. When they put it on, they're the only people allowed to take it off. If you tamper with it, It's gonna be a violation of your probation.
Oh, let's not do that then.
Okay, all right, thank
Okay,
you.
thank you, Judge.
All right, thank you, ma'am.
You're welcome. Anyone else ready? Yes. Rodney Wiggins. Court.
Your Honor, I'm asking for a reset on this case, Your Honor. He hasn't
Where is he?
unindicted. He's in custody. I guess he was on hold. They said they had like 200 prisoners and they didn't know when they were gonna get him. But I can see him right after this and visit him.
Where is she?
She's right there, Judge.
Come up, Ms. Ramirez.
The state wants to do a 6-month extension for her to finish her treatment. She's had a couple of positives. I had a chat with her.
I'm not down with that. I'm not down with you just continuing to drink. You're not supposed to, that's the first damn elementary thing of this program is you don't drink. And you're continuing to do it. It's not gonna happen. You know, I mean, do we need to put her into an inpatient treatment program?
They're recommending IOP and SOP.
The cost of an inpatient, because with DWI-PTI,
Oh, I'll revoke her bond. It'll be free.
hopefully we don't do that, Judge. Can you give her a chance to do the IOP, SOP? I had a chat with her.
You want to keep in this thing? I'm gonna put you in inpatient treatment. You're gonna go right now. There goes your life. 6 months minimum. And if you're good, 6 months, right? If you're good, I'm sorry, 6 months. Otherwise, it's a year and a half in custody. You know, no means no. Doesn't mean I've got a party. I've got Jesus telling me to do it. No. How many positives? Let's not get ahead of ourselves.
So she completed the DWI education, effective decision-making and victim impact. On March 12th, she admitted to consuming alcohol. And then on June 20th, she provided a flow of 1.53.
0.153, that's nearly double the legal limit. That's gotta be, that's
When the probation officer.
like eight drinks.
She said she had 10 drinks and she was celebrating her sister's birthday.
No, there's gotta be some kind of sanction. No,
Judge, can we do, instead of putting her in inpatient, can we maybe take her in for the weekend and then let her out and go her with?
I'm okay with that. Yeah. And then at that point, I'm gonna put an ankle monitor on her.
Can you let her come in? Did you drive here?
Yes.
Can we, if, her car is gonna get towed. Getting her
And
car out
I
of
care
impound.
because,
Well, so I know this is not the court's concern. I'm saying my concern for her is that if you take her in right now, her car is gonna go to impound. Her family can take it out because they need a power of attorney. She's gonna come out with over $1,000 in fees only to get her car out. But she will come back.
we continue to cater to everybody. And you know, I get killed all over YouTube because people say I'm so mean. I mean, are we supposed to coddle everybody? Are we supposed to coddle you for just 10 drinks when you know you're on a freaking probation? Shameful. You ought to be ashamed. That tells me that you either have a problem or you just don't give a shite about us. That's what that tells me, you know? And yet you still want a dismissal of this case. It doesn't work like that, you know?
I don't know if it makes a difference, but I've had her on bond for quite some time. And she's been on the program, she did her classes. If you give her a chance to come back, and if she doesn't do it, then I won't even have anything to stand on or come before you to say anything. And I don't think she will either. And being before you, I think she understands, right?
Yes.
Right? That if she does not take advantage of this opportunity, then that will be the end of that program for her.
Yeah. We're going to have Pavel. So, you know, I'll tell you the only way is 3 days as a condition, and she'll have to turn, I mean, do you have a license? Can you run her license, please? She'll have to do the 3 days, and then as soon as she gets out, immediately she'll get a scram.
Okay.
She'll have to pay for it because I can't pay for it, you know?
Well, since it's a contract with the state, I guess you could drive with the scram.
I want to make sure first she has a license. Okay, do you have insurance?
Yes, I do.
Okay. Hey, Pavel. I need you to please amend the contract, and I don't know how, but so this is Miss Ramirez.
Okay.
She's had quite a number of blows, positive.
Okay.
We're amending to do 3 days as a condition, and then she's on the PTI. Yeah.
Okay.
Well, and then the other issue is that if you want to put her on a scram, then we need to amend the contract to reflect scram, but allowing her to drive. Because normally the way that it works on your template contract is if she gets a scram, then automatically there's a non-driving affidavit.
Right, no.
So
We'll
that-
keep everything as is, but I want to make sure that she's not at all times, she's not consuming. Whereas here, all she has to do is blow, right? So we'll do the extension, but that's the conditions, right? So 3 days is a condition to begin, I guess, within the next couple days.
So
And
how
then
do you?
upon release, she has to get the scram, and then she has to do IOP and SOP.
How do we do that? The sheriff won't take her in. So if she shows up, if it's a civil contract, we can do in the contract 3 days as a condition, but if she shows at the jail and says, the sheriffs won't take her in because there's nothing in the.
Melissa?
Can she do it, Judge, she's a full-time student, can she do it over the weekend, like go in next Friday and come out on Sunday so she doesn't miss school?
What days are your school? See, I mean, we continue to cater to people. That's all we do here. We cater. It's like,
The only way she can do the 3 days is if you revoke the law. So whenever she wants to go in, she has to come in, and then we have to revoke it, and then you have to bond reinstate it whenever you want her to get out.
I just want to make sure that from a practical perspective, we can get it done, so she, what
if you ever test positive again, you're gonna lose 6 months to about 1.5 years of your life. Do you understand me? So if it'll be the best damn party, best damn beer, best damn drink, best damn smoke, whatever it is, you ever test positive again, I'm telling you, inpatient you go. Because it really tells me that you have a problem and you're incapable of stopping on your own. So we'll do it for you. That's it. Okay, so I guess let's reset the case between now and what's your school schedule like?
I have class Mondays and Wednesdays, in the morning and the afternoon.
What about Thursdays?
Thursdays, no class.
What about Fridays?
No class.
Okay, so let's start on Thursday then. Okay, because that way she'll get a bed. Otherwise, she'll be sleeping on the floor. Too many people going in on Fridays. They sleep on the floor, as opposed to if you go in on a Tuesday through Thursday, you get a bed. So we'll have you come back here on Thursday. Can you amend it between now and then?
I've never done that. I'll see if that's even possible.
I don't think.
Anything can happen,
Well,
man.
Judge, if
Really?
But if you revoke her bond and she goes into custody, let's say we do Thursday, well, probably better Friday, so we can have her on the docket on Friday and Monday.
Okay,
And then
I'll
we come back
reinstate
on
on Monday.
Monday, you reinstate her, we don't have to amend anything.
all right, good.
Just so we can kind of,
I understand. Okay,
that's, okay.
Yep. Okay.
And then we'll just amend, if you want to do the scram, then they'll just amend that.
I mean, if they tell me that they can't do that, then I'm not going forward. I'm not gonna do it. Because it's not fair that she's out drinking 10 beers or whatever, 10 drinks in one night, and it's a slap to the face and everybody else that actually complies with this thing. No way. I'm not gonna do it. So, okay, we'll see you on Friday. So.
Thank you, Judge. As we stated in our motion, Mr. Murphy entered into this agreement on the understanding that Ms. Taft was terminally ill, and based on her representations to Mr. Murphy would be dying within the year. The agreements that he agreed to essentially are unconscionable, especially given the fact that there is a massive divide between Mr. Murphy and the children now. He doesn't have the parenting time that he would have wanted, but obviously gave more parenting time to Ms. Taft, given her assertion that she was dying. He wanted to keep things as even for her. Even isn't the correct word, but essentially he wanted to make sure that she would have a decent rest of her life. So they didn't divide the business. A lot of the things that they kept around, like the country club dues, the tickets for the baseball and football or basketball and football games. Essentially he agreed to this on the understanding that she was going to be passing. If she's not, and he has tried to communicate with her and say, hey, what's actually going on? Because I'm being told that you aren't terminally ill, and that you induced me into agreeing to this agreement without under a false allegation. So essentially, Your Honor, what we're asking for is an evidentiary hearing so we can put proofs on the record to say Mr. Murphy did enter into this agreement under duress, that he believed false information presented by Ms. Taft. Even within his pro-con, he stated, and I'm not going to quote this directly, but he stated an understanding that he was entering into this agreement due to her terminal illness, without counsel, without representation, and simply signed the dotted line due to the misrepresentations that she placed to him. So, Your Honor, we're looking for an evidentiary hearing to prove that misconduct did occur, and then to move forward with this matter. Thank you.
Thank you. Mr. Schaefer?
Your Honor, we have filed an extensive answer to this. Number one, we submit that this is an improper motion for a number of reasons. Number one, the allegations alleged that my client said are not true. Next one is that it's pretty obvious that it's under duress, pressured based on the allegations therein. Number three, this was filed because my client hasn't died yet. Well, they didn't even give her a year. It's February 29th judgment. I represent to this court melanoma. It's in remission at the present time, and to see that there's something inequitable about this. What is improper on this is that counsel for the other side signed these pleadings knowing that the business was owned by both of the parties. We have submitted evidence of that, and this was filed just before there is a oppression suit that's going to be filed in relation to the division of the business. Client is asking for costs and sanctions in that regard because both the client and the attorney signed pleadings knowing that there's a 50-50 ownership in the business. My client has never used her melanoma in any way to affect judgment. It was a choice by a defendant not to be represented. He had been represented around this matter and chose not to. That was his decision. Now he is crying sour grapes. His allegation about the children, his relationship with the children at the time was poor at best and did not exercise his parent time at this time. We submit that this motion is unfounded in fact and law, should be dismissed, and that costs should be assessed in relation to the improper pleadings.
Thank you. Anything else, Ms. Capture?
Your Honor, the pleadings aren't improper. Again, this is not so much about the allegations that this is a jointly owned business. We admit in our in our motion that there's a marital interest in this. Again, Your Honor, this is simply about the misrepresentation by Ms. Taft that she's terminally ill. She induced my client into signing a divorce decree to get this settled so that she could live in peace the last time, however long it was going to be. Mr. Murphy has requested on numerous occasions, can you just communicate with me about what's going on? And she refuses to. And now he is being told by her numerous friends and family that she is not in fact terminally ill, nor was she ever terminally ill, and that he agreed to this under the misrepresentation that she was. Again, Your Honor, we state in our motion specifically that we are just simply asking to have all of this resolved. However, Ms. Taft will not communicate. And if she is going to continue living, which is great, good for her, we want her to be in remission, we want her to be healthy. But if she's going to continue, obviously the marital property needs to be divided appropriately, including the business. That's not to say that we are saying, well, we shouldn't ever divide the property. We simply need an answer, and we need the correct answer, not a lie. If she's going to be passing on, well, then let's get that resolved, and we would withdraw our motion. But we obviously, she's in remission, allegedly. So then she obviously didn't have terminally ill melanoma like she represented to my client.
Well, in this matter, the court does note that fraud has been alleged, but as I go through the pleadings here, the argument, there's been very little factual basis for the allegations. I don't believe that in this matter, the defendant has set forth a prima facie case for the court to again intervene at this time. And so the court believes that if in some time in the if the defendant can develop those particular facts, then the defendant can file an amended motion in this matter. But at this point, the court doesn't believe that there's a factual basis in this matter other than a he said, she said. And as a result, the court will deny the motion at this time. And the court doesn't believe there's a basis for award of costs or fees. So I will deny that request by both parties and ask Mr. Schaefer, you prepare the order denying the motion.
I will, Your Honor. Thank you.
You're free to go. Have a good day.
Thank you, Judge.